Speaker, I thank you very much and I apologize. I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, and for other related matters be now read a second time. When we look, Madam Speaker, at the amendment bill which I have the privilege to pilot today, that is to say, the bill entitled the Sexual Offences Amendment No. 2 Bill 2021, one might be tempted because of its brevity to regard it at first blush as a simple amendment. We are assembled here today to further amend only 3 sections of that act as already amended. That is to say, sections 48, 56, and 57. I will come to those, but permit me to make some prefatory remarks. We remind ourselves of the importance of the original Sexual Offences Act number 27 of 1986, both with respect to its constitutional import and its historical significance, given the indisputable importance of addressing the societal ill in our society targeted by this legislation. In that regard, Madam Speaker, I remind myself of what to me is an enduring theme, which in my view is central to our purpose here, a theme which is very well put by Mr. Victor Crabb in his text Legislative Drafting. Law does not operate in a vacuum, statute law less. A statute is intended to guide and regulate the conduct and affairs to whom it is addressed. Its context thus takes cognizance of the cultural, economic, political, and social conditions of the society within which it is intended to operate. Legislative Drafting by V.C.R.A.C. Crabb, first edition. Madam Speaker, the constitutional importance of this legislation stems from the fact that the original act is one which impacted then vested constitutional rights, and at its passage in 1986 required the requisite 3/5 majority vote of members of this Honourable House. Its historical significance includes, as already stated, the need to address a grave societal ill. As well, that history reminds us that at the time of its passage in 1986, the then Prime Minister, the Honourable Mr. George Chambers, leading the People's National Movement in government, was committed to the serious duty of attending to serving all the people of this country to address those societal ills which required legislative intervention for the protection of the vulnerable in our society and to bring predators to account. The opposition, then led by the Honourable Mr. Basdio Pandey of the United Labour Front, supported the passage of that original act to permit the constitutionally requisite 3/5 majority. Madam Speaker, the social conditions of this society within which this legislation is intended to operate and to regulate is one which we as a parliament recognize and must not shirk from. My immediate predecessor in office, the Honourable Member for San Fernando West, has already placed on the record before you that as recently as 2020, that other arm of government, the judiciary, in a signal High Court judgment, had cause to remark with concern on this social reality. It is our solemn responsibility to ensure, as we improve our legislative framework which this Act creates, that we heed the cautions which have been sounded for us. That judicial caution bears repeating as we remind ourselves, therefore, that no amendment to this significant social legislation is a simple matter, since we must continue our vigilance to ensure that we continue to protect the vulnerable as proactively as due process will permit. In the opening paragraph of the sentencing note of the judgment of Mr. Justice Hayden Sinclair Douglas of the High Court of Trinidad and Tobago, delivered on the 9th December 2020, beg your pardon, the judge commenced with the following quotation from a vulnerable female member of this society, quote, "I never completed school as a result of my kids at a young age. I had my daughter at the age of 13 years. I was then a Form 1 student and the school name is given. After giving birth to my daughter, I went back to school and continued my schooling. I had advanced to Form 2, but became pregnant again with my son. I was 14 years old. I never returned to school after having my son. The judge next commented, quote, "These are not the words of a young female in some isolated plantation or faraway rural community in the 1940s Trinidad. These are the words of a young female who resides in an urban community in Trinidad in the 21st century. In the view of this court, this is unacceptable." After sentencing the offender, he ordered inter alia that information regarding the offender be published on the website which this legislation authorized. This was the first judgment of its kind in this jurisdiction, as it related to the publication of a registered sex offender's personal information pursuant to the 2019 amended Sexual Offenders Act. There is a clear distinction between the National Sex Offenders Register and the Public Sex Offender website. The judge's request to have the sex offender in that case placed on the website could not be accommodated, given that an offender's information can only be published on the website when he has completed his sentence, as opposed to upon conviction. Madam Speaker, the purpose of seeking today's amendment is consistent with our responsibility of continued vigilance in respect of the proved efficacy of the legislation. In order to address this lacuna, the amendment specifically provides timelines for when a person must be placed on the website, whilst acknowledging that person's due process rights. The amendment also provides for some clarification. Accordingly, with respect to Section 48A, 56.2, 57.3c, 57.4a, and 57.4b of the Act, this Honourable House is asked to amend the Act as amended for the following reasons. In respect of Section 48, subsection 8, the fact of the matter, Madam Speaker, is that Section 48 provides that the Commissioner of Police is responsible for maintaining the website and ensuring that information published on the website is accurate. With respect to updating the website and the published information, where there is a change in information, which goes to the purpose of the amendment regarding the sex offender or registered sex offender, it was noted that there is no express time frame in which the Commissioner of Police is mandated to update the information. Therefore, this amendment is inserted to provide for greater clarity with regard to the duties of the Commissioner and the time frame, that is to say, without delay, in which he is required to update the information on the website. With respect to Section 56, subsection 2, the word offence therein is incorrect in the context and has been changed to sentence. The amendment is also necessary for consistency with the remainder of the section. With respect to Section 57.3, subsection C, that subsection provides that the designated officer verifies the information provided by the registered sex offender before he enters it into the register within 7 days of the receipt of such information. Section 57.4a provides that where this information is verified by the designated officer, he shall record the change in the register within 2 days of the receipt of the information. When read in conjunction, Sections 57.3c and 57.4a were illogical, as they imposed contradictory timelines. Further, the wording of Section 57.3c required clarity. Therefore, an amendment was necessary. The amendment to Section 57.3c, therefore, is to provide greater clarity in imposing a time frame of 7 days within which the information provided by the registered sex offender must be verified by the designated officer. Further, the amendment to Section 57.4a changes the word receipt to verification to provide clarity to the procedure which follows the action under Section 57.3c. With respect to the amendment 57.4a, in 57.4a, the word receipt has been changed to verification, as the information must first be verified within 2 days of the receipt of same before it can be recorded on the register. With respect to Section 57.4b, this amendment was made to provide a time frame of 3 days for the Commissioner of Police to update the change in information on the website upon receipt of same. Madam Speaker, I beg to move.
Honourable